Hello and welcome to The Hindu. The Supreme Court of India on April 8, 2025 delivered a significant verdict delineating the powers of the President as well as the governors with respect to grant of assent to bills passed by state legislatures. The judgment has received both bouquets and brickbats across the country. The recent criticism against it has come from Vice-President Jagadeep Dhankar, who has scoffed at the judiciary for having acted as a super parliament. On the other hand, a careful reading of the 415-page verdict delivered by Justice J.B. Pardiwala and Justice R. Mahadevan shows that it had actually emerged out of arguments that it is the governors in the country who should not be allowed to act as super constitutional authorities by permitting them to veto or pocket veto the bills passed by state legislatures. The Supreme Court appears to have been quite conscious of the fact that it could not encroach upon the domain of the Parliament by reading in timelines spanning between 1 month to 3 months for the President and the governors to act upon the bills. Therefore, what the top court did was not to read in the timelines but only prescribe them, explaining the difference between reading in the timelines into the provisions of the Constitution and mere prescription of the timelines. The court said that the former would lead to the bills being deemed to have been granted assent if the President or the governors do not act within the fixed time limits, whereas the latter would only open up the scope for judicial review. To put it in simple terms, what the Supreme Court said was if the timelines were not followed, the bills would not become laws automatically. Instead, they would open up a window for the state governments to approach the courts. The courts in turn would see whether there is sufficient cause for the President or the governor to have been not able to adhere to the timeline and then pass appropriate orders on a case-to-case basis. Authoring the verdict, Justice Pardiwala had underlined that only reading in the timelines into the provisions of the Constitution would amount to altering their structure, whereas the mere prescription of the timelines per se by the judiciary would not amount to alteration or amendment of the Constitution. So this is the basic difference between reading in the timelines into the provisions of the Constitution and mere prescription of the timelines. After taking note of the corresponding provisions in the constitutions of many countries across the globe, the Supreme Court pointed out that the Constitution of the United States of America and even that of the Islamic Republic of Pakistan prescribe time frame for their presidents to act upon the bills, failing which the bills would be deemed to have been granted assent. Now, what is important is to note that no such provision prescribing timeline or deeming consent had been incorporated in the Constitution of India, though the draft Constitution presented to the Constituent Assembly had actually fixed a time limit of 6 weeks for the President of India to take a call on bills passed by the Parliament. Now, what happened in the Constituent Assembly is that Dr. B.R. Ambedkar, who moved an amendment to replace the expression not later than 6 weeks in the draft Constitution with the expression as soon as possible. Now, the Constituent Assembly members P.S. Deshmukh and H.V. Kamath had vehemently opposed the amendment moved by Dr. Ambedkar. These two members insisted on fixing a time frame for the President to act upon the bills. Speaking at the Constituent Assembly on May 20, 1949, Mr. Kamath said, "It was in human nature to procrastinate unless there was a compelling sense of duty imposed upon an individual holding the office of the president, and therefore it was necessary to fix a time frame for the president." Nevertheless, after elaborate deliberations, the Constituent Assembly decided to substitute the expression "not later than 6 weeks" with "as soon as possible", and it was adopted mutatis mutandis in Article 200, which relates to the powers of the governors to grant assent to bills passed by state legislatures. Now, Justices Pardiwala and Mahadevan in their verdict point out that even the use of the expression "as soon as possible" in the provisions of the Constitution reflects a sense of inherent trust reposed by the Constituent Assembly that the President and the governors would execute their functions in a timely and efficient manner. This did not happen is a matter of fact. The court took note that there had been numerous complaints from state governments of the constitutional authorities sitting over the bills passed by the legislatures indefinitely without taking any decision, or withholding assent to those bills without assigning any reason. The judges wrote that the delay on the part of the constitutional authorities without any justification or necessity would fall foul of the basic constitutional principle that the exercise of a power must not be arbitrary or capricious. The court pointed out that the issue had gained the attention in the recommendations of the 1983 Sarkaria Commission report as well as the 2007 Poonchi Committee report, which dealt with center-state relations. Now, both the Sarkaria Commission as well as the Poonchi Committee had recommended that fixed time frame must be laid down for the President and the governors to act upon the bills passed by the state legislatures. Apart from these reports, the two judges of the Supreme Court also took cognizance of a very important piece of document, and this is an office memorandum issued by the Union Home Ministry on February 4, 2016. This office memorandum insisted that the bills referred by the governors by exercising their powers under Article 200 of the Constitution to the President for acting upon under Article 201 of the Constitution must be considered within 3 months. Therefore, the Supreme Court had now actually taken a cue from the Union Home Ministry's office memorandum to fix a time limit of 3 months for the President of India to take a call on bills passed by the state legislatures and referred to the President by the governors under Articles 200 and 201 of the Constitution. Right now, there are reports that a review could be filed before the Supreme Court against this judgment. It would be interesting to note the grounds on which the review is to be filed and whether the Supreme Court would entertain the review at all. And when all this happens, we shall bring you all the updates. To keep a tab on the developments, do not forget to subscribe to The Hindu.